Greetings. My name is Gary Bourne, and I'm joined by my partner, Rachel Kent. And we have the distinct honor, the privilege on behalf of MBL to give this webinar on intellectual property arbitration, a 1-hour guide.
So we'll start by defining the intellectual property rights that we'll be talking about. Intellectual property generally describes creations of the mind, and there are multiple types of intellectual property. The ones that are most familiar to you and the ones that we'll be focusing on are patents, which are intellectual property rights that are granted for an invention. They protect inventors by granting exclusivity for the use of that invention for a period of time. Patent rights also benefit the public by providing access to information about inventions. Second type of intellectual property is copyrights. A copyright is a right that creators have over original artistic, scientific, or literary works, including things like books, music, movies, art, but also things like computer programs, technical drawings, and maps. The third type of intellectual property is trademark. A trademark is a mark or sign that distinguishes particular products or services of the trademark's owner in the marketplace.
And moving on to how it is if, unfortunately, an intellectual property dispute arises, parties, in a sense, always have a choice, at least at some points in the narrative. They have a choice between arbitrating their disputes on the one hand, or alternatively, litigating those disputes. And within each of those categories, they also have sub-choices. If they're going to arbitrate, how will they arbitrate, institutional or ad hoc, which institution, and with respect to litigation, what national court or courts plural will one wish to litigate in. If we could move on another slide and focus on what's, as a general proposition, beneficial with respect to international arbitration as a means of resolving all types of disputes, whether it's intellectual property or otherwise. I like to characterize this question as being answered by the 6 E's of international arbitration. Life is, of course, all about competition. And so what one needs to do is to compare arbitration on the one hand to litigation on the other hand in order to decide what in a specific case for a particular party is more beneficial, is more advantageous.